Ms. Kobach, if I could just start with you, let me ask you a question about the First Amendment, if I could. Does the First Amendment apply to the medium of the internet, in your view?
My understanding is that it does, Senator.
Why would that be true, considering that the internet didn't exist in 1791?
Well, Senator, the Supreme Court has adopted a number of different tests for assessing the constitutionality of different provisions. The First Amendment protects speech, of course, and people speak on the internet. But I would adhere to the relevant test if any First Amendment case were to come before me.
Well, I ask you because the Supreme Court has said something much the same in the Second Amendment context. And in the Second Amendment context, you argued to the Supreme Court that because a particular firearm did not exist at the time of that amendment's ratification, that it wasn't covered. The Supreme Court, covered by the right, that is, the Supreme Court rejected your opinion unanimously in a per curiam opinion. That's the Caetano case. I've got it right here. You've been asked about it. You know, what's interesting to me about this case is there's a lot of division on the United States Supreme Court about a lot of topics, including the Second Amendment, but they were unanimous in this case. It's a very short order, 2 pages, not even, really, page and a half, in which they rejected your argument completely out of hand. And I just want to ask you, why did you make an argument that the Supreme Court said held no water at all, so much so that they felt the need to address it in a per curiam decision and to remand the case, saying that the arguments that you made were not to be countenanced at all? You didn't get a single vote. So tell me, help me understand, why did you make arguments that the Supreme Court said had previously been made and previously rejected by the same court?
Thank you, Senator. I just would like to clarify at the outset that I did not handle the Caetano case when it was before the Supreme Judicial Court. The case was handled by the district attorney rather than the Attorney General's office at that stage. In the Supreme Court, the argument that I made—
Wait a minute, you didn't, the Caetano case at the U.S. Supreme Court, you didn't handle it?
I did co-author the brief in opposition to certiorari at the Supreme Court,
okay,
but not the Supreme Judicial Court.
I'm asking you about the Supreme Court,
sure,
the Supreme Court judgment that rejected your arguments. So you've just confirmed, I think, that you made those arguments to the United States Supreme Court. Is that correct?
Respectfully, Senator, the argument in that brief was slightly different. The argument was that a stun gun is, we argued on behalf of the Commonwealth, not an analog to a founding era weapon.
Which the Supreme Court rejected unanimously.
The Supreme Court held that the Supreme Judicial Court had misstated the Heller decision in 3 respects. But again, I didn't handle the case in front of the Supreme Judicial Court.
So your argument is that your position wasn't rejected unanimously by the U.S. Supreme Court?
I certainly acknowledge, Senator, that the Supreme Court summarily reversed the Supreme Judicial Court's decision. And I would adhere to the Supreme Court's holding in Caetano and reaffirmance of Heller's statements.
Here's what I'm trying to understand. The Supreme Court was very dismissive of your arguments. One of the reasons it was dismissive is it said they've considered these arguments before and rejected them. This is why they then rejected your arguments per curiam unanimously. So I'm trying to understand why someone who has ethical obligations to the court, why you would make arguments that the court has previously rejected, knowing that they'd previously rejected them. And then here's the other thing that interests me. In this case, the person who had been arrested under this law that the Supreme Court then reversed on was the victim of domestic abuse. And I just want to read a few of the facts here. This is from Justice Thomas and Justice Alito's concurrence in that per curiam judgment. Here's what they say. After a bad altercation, that's from the trial record, with an abusive boyfriend that put her in the hospital, Jamie Caetano found herself homeless and in fear of her life. So she obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, she accepted the weapon. And it's a good thing she did. Because one night, after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was, this is from the trial record, not gonna effing work at this place anymore because she should be home with the kids they had had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She stood her ground, displayed the stun gun, and announced, "I'm not going to take this anymore. I don't want to have to use this stun gun on you, but if you don't leave me alone, I'm going to have to." And the gambit worked. The ex-boyfriend got scared and he left her alone. You think she shouldn't have had the right to self-defense?
Senator, thank you. Again, the district attorney made the decision to bring charges in the Catano case. The Attorney General's office and myself were not involved in that decision, but I certainly recognize
That you argued for it to be upheld before the United States Supreme Court.
Senator, the argument in that brief was that the Supreme Court should deny review of the case.
Right,
But I
which
take-
denied the right of self-defense to this person. I'm asking you why.
Senator, my duty as Assistant Attorney General was to represent the Commonwealth in that case when it came to the Supreme Court, and I did so consistent with my ethical obligations.
Your duty is not to make frivolous arguments to the Supreme Court of the United States. And frankly, I question your judgment in what you did in this case, and I question your judgment in choosing to try and perpetuate what is manifestly an injustice to this victim of domestic abuse. I yield the rest of my time.
I'm going to start with Ms. Kobach. I want to ask you about your work on cases involving Second Amendment, specifically about the Catano case. The Supreme Court held in Heller, as you know, that the Second Amendment protects the right to own arms that were, quote, not in existence at the time of the founding. It rejected a claim to the contrary as boarding, quote unquote, boarding on the frivolous. But in a few years later, Catano, you argued that stun guns were too modern so that they were protected. So I'd like to have you explain your thought in regard to that, whether it was consistent with Hellard, and at the same time, could you explain why the briefing didn't address the Supreme Court statement that the Second Amendment protected arms that, quote, not in existence at the time of the founding?
Thank you for the question, Ranking Member Grassley. In my capacity as Assistant Attorney General, I was assigned to write or co-author the brief in opposition to certiorari in the Catano case. The initial decision to bring charges was made by the district attorney, and the district attorney handled the case at the trial court level and on appeal in the Supreme Judicial Court. So our role, the Attorney General's office took over representation of the case when the case reached the Supreme Court. And our argument in the brief was simply that the Supreme Court should deny the petition for a writ of certiorari. I certainly understand the Supreme Court summarily reversed the SJC's decision in that case, stating that the SJC's decision was inconsistent with Heller in 3 respects. And I want to affirm, Senator, that in every case I've handled involving the Second Amendment, my arguments have been based on Heller and McDonald, and I would adhere to all of the Supreme Court's precedent on the Second Amendment, including its recent decision in Bruin, if I were so fortunate as to be confirmed.
Okay, thank you.
Let's see, Ms. Kobach. Let me come to you. I heard your response on the Catano versus Massachusetts case and your assertion that you would follow Supreme Court precedent when it comes to Second Amendment rights. So tell me what your understanding is of whether the Second Amendment applies only to militias.
Senator, the Supreme Court held in the Heller decision that the Second Amendment protects an individual right to keep and bear arms.
So you would stick with that?
Absolutely, Senator.
Okay. And let me ask you this. Why is it constitutionally permissible for the right to keep and bear arms, which the Supreme Court has called a fundamental right,
Yes.
that right to bear arms, but that right is subject to the discretionary issuance of a license by a local official?
Thank you for the question, Senator. I know different jurisdictions have different statutes related to licensing. If a case were to come before me involving a Second Amendment challenge to a licensing statute, I would certainly apply the Supreme Court's precedent, including the methodology clarified by the court in the Bruin decision.
Okay, thank you.
This isn't a question. Judge Gray, I may vote for you anyway, but I'll commit right now in front of God and country to vote for you if you'll move back to Louisiana. Judge Lynn, I've read a number of your writings. I want to, you wrote an article in December of 1998 entitled Person of Faith, Race and Religion as Experiential Knowledge. You wrote it in a journal called Perspective. And this is what you said, I quote, your words, not mine. The problem with the Christian Coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots. End of quote. Did I quote that correctly?
I believe you did.
Did you write that?
I did write that when I was 18 years old, or 20 years old, excuse me. I do want to be clear. I do not agree with that today. I wrote that before I went to law school, before I had any kind of
You were a
profession-
grown woman when you wrote this.
I'm sorry.
You were a grown woman when you wrote this.
I was 20 years old when I wrote it. It was before I had a professional career.
You were in your third year at Harvard?
I was
I've seen you at Harvard.
I was a junior at Harvard.
Junior. So you were 3/4 of the way through your Harvard education, and you wrote that.
That is correct, Senator. It is
Wow.
20 years before I became a judge. I do
Wow.
not agree with it today. I do want to be clear about that.
Okay. Judge Simmons, let me just ask you a couple of questions. You finished law school in 2004?
Yes, sir.
All right. Have you ever tried a case in federal court?
I have not seen there.
Have you ever filed a brief in federal court?
I have not practiced in federal court. My entire practice has been in the state court.
Okay. Have you ever argued a motion in federal court?
I have my entire practice of over 12 years as a prosecutor has been in state court, Senator.
Okay. Have you ever, you serve as a state court judge, have you ever presided over a jury trial as a state court judge?
In the 5 years that I've been on the Superior Court bench, I have been in a moving department, and now I'm the supervising judge.
Have you ever tried a jury trial?
As a attorney, I have tried.
No, as a judge.
As a judge, I have presided over court trials, not jury trials, sir.
No, so the answer is no.
I have not presided over jury trials as a
Okay.
judge.
Have you, in the 5 years you've been on the state bench, have you ever written any opinions, issued any opinions?
Well, sir, I've been in moving departments in the 5 years that I've been as a Superior Court judge. We don't issue written opinions in moving departments on the
So the
Superior Court.
answer is no.
In the 5 years I've been on the Superior Court, I've been in moving departments. We don't issue written opinions in moving departments.
Okay. What is the standard of review in federal court for questions of fact?
For questions of fact by the trial court, it is clear error, sir.
Okay. What's the standard of review for questions of law?
In the trial court level, it's de novo.
Okay. What is what's the holding in Map v. Ohio?
Map v. Ohio, since I've been practicing as a district attorney for the last 12 years, as well as a Superior Court judge over the last 5 years, I know what the holding is. It escapes me as I currently sit here, but
Okay.
as a Superior...
What's the Chevron doctrine? You'll see that a lot.
Yes, Chevron deference refers to an administrative agency that's interpreting its own rule. It created a two-part step test. The first step in that test is whether Congress was clear.
You know it. I got you. What's the political question doctrine?
I have not, as a Superior Court judge, and over the last 5 years, and as a deputy district attorney for 12 years, I have not practiced in a federal court. So if I am so fortunate enough to be confirmed, I will obviously apply the applicable law.
Okay, I want to talk about the United States Constitution. Is it a doctrine of plenary powers or enumerated powers?
Enumerated powers, sir.
Okay. I yield back 1 second.